welcome to the first episode of the Conduct Detrimental podcast. My name's Dan Worley. I'm joined by my co-host, Dan Wallach. Dan, how are you?
I'm doing great, Dan. How did we ever come up with the name Conduct Detrimental? We just pulled that one out of a hat, huh?
Yeah, I would say that, people that follow us on Twitter will say that they would have guessed this name for us. But, it's obviously a hint, a nudge at the NFL's rule on conduct, and I think that it's a good one. It talks about what we're going to be talking about, which is sports legal issues.
Yeah, I mean, almost everything that's continuing in this cycle of the intersection of sports and law. I mean, we're talking about bad conduct or athletes accused of crimes, whether it's in the discipline setting or the criminal setting. I mean, this kind of captures the whole bailiwick, or most of it, at least recently, of sports law. And I think it was a fun, catchy name. I mean, because you and I both experienced the Twitter ascension, in Deflategate, and certainly got a lot of eyeballs on our accounts. Mainly because Tom Brady was accused of letting air out of a football. I mean, for that one case, our respective Twitter followings grew, astronomically. And I don't think I'd be here today with as many followers as I have, and certainly the attention that you and I both have, if it wasn't for the catalyst known as Deflategate. So I will continue to pay homage to the case which hopefully launched us into the podcast and will lead to us to continue to do good things. I know it gave me the confidence to, wade in deep in sports law, because before Deflategate, I was just touching on, issues relating to sports betting, daily fantasy sports. I think Deflategate was my first mainstream foray into the world of sports law, and I got addicted. And, as evidenced by the fact that you and I are now doing a podcast.
Right. And we will definitely touch on, the NFL and Deflategate and Peterson and Conduct Detrimental more specifically at a later date. But, I think today we're here to talk about the case of the hour, and that is the Derrick Rose trial, which just went to verdict yesterday. He was found not liable on all accounts. Him and his two co-defendants were.
Oh, I think you're the first person to actually say not liable rather than cleared of rape charges or not guilty.
Right. I saw a lot of not guilties out there. And
yeah, I think a prize should drop down from the ceiling. I think you should get something for actually being one of the first people to clarify that.
Right. And we wanted to touch on the case a little bit. I mean, we've both been reporting on it. I've been writing about it frequently on my website, The White Bronco. Gathered all the testimony from what we heard from the few reporters that were in the courtroom. But, what were some of the things that stuck out to you as far as strengths in each side's case? And, obviously, since Rose won, what were the things that ultimately tipped it in his favor?
As I'm making a list of what I believe to be the good facts for Rose and the good facts of, in favor of Jane Doe, the accuser, there's a lot more in the Rose column that's favorable than in the Doe column. And, when a jury is being asked to consider, something as serious as a sexual assault, and you need to have a unanimous jury verdict, and the jury has to be persuaded by a preponderance of the evidence, I think you would need a lot more on the Doe side favoring, her case than on the Rose side. And as the case unfolded, it just seemed to me that more boxes were checked in the Rose column. I mean, you have the issue of what stuck out to me was the text messages and the evidence of her being trapped or caught in prior lies. I mean, this is a woman who's presenting herself to a jury as a victim. We don't expect her to be, airtight and without flaws. But a couple of those lies about, about going to visiting the sex store and the hiding of a few of the text messages allegedly, I think that started to kind of poke away at her theory of the case. Certainly, from a time standpoint, the big issue, the number one issue that I saw, at least as the jury recounted it, is the distance, the lack of the absence of any police report for at least 2 years, no rape kit, no evidence of a date rape drug. I think the length of time between when the incident happened and when she decided to commence a lawsuit or an investigation on it was way too long, in my opinion. Not that that's dispositive, but I think that resonated with the jury. Do you agree?
Yeah, I agree with all of that. And just to, one of the points that I had written down was certainly the text messages. And the big issue what happened at trial is that Doe's lawyers actually put up on a projector a list of text messages. And among these text messages were text messages they hadn't produced to the other side, which is, in civil litigation, is a big no-no. Rose's lawyers astutely caught on to that, noticed that they hadn't seen these text messages. I think it was an opening argument or opening statements. And they caught on, brought it to the judge's attention, and the judge eventually had to tell the jury about this. And I think that really eroded at Doe's credibility in the jurors' eyes. And I think it's important to remember in a case like this, like you mentioned, where there's a lack of physical evidence, it does kind of turn down to a he said, she said discussion. So credibility of the witnesses is absolutely key in these cases.
You pointed or you hinted at something that the text message issue, I think, goes to an issue that's probably worse than lying: concealment. And this may have been unintentional and inadvertent. It's quite possible that the plaintiff's lawyers keep really crappy records and don't bait stamp documents. And, for those who don't practice in litigation, when you turn over documents as part of civil discovery, there is a very painstaking way of memorializing what gets turned over to the other side. And it seems to me that at worst, this was very sloppy, practice by the plaintiff's attorney. And at worst, it was active concealment. And in the jury's eyes, active concealment is worse than lying. The cover-up is worse than the crime. And that could have resonated to some degree with these jurors.
Yeah, I agree totally. And another thing that, going into the case, I wrote this extensive preview. I had, dived into all the expert reports, the text messages, the proposed testimony.
I learned everything about the case from you. I read the primer. I read your trial primer a couple of days ago in fall, and then about an hour ago, what you did was this brilliant thing. It was like this GIF of tweets from every reporter in the courtroom set up chronologically. It was like watching the trial.
Yeah, obviously kind of a highlight version of the trial. But when I was putting together the trial primer, I thought that one of the biggest things in Doe's favor was that she was going to be able to prove intoxication. She had both experts in the case in their expert reports said that she was intoxicated, which, usually when an expert report's coming from the defendant's side, it won't say that. And I think that Rose's lawyers did a good job of kind of batting back this evidence, and they got her to admit that she stopped drinking hours earlier than we originally thought. I believe she said at 11 p.m., and the alleged incident didn't occur until 3, so there was a 4-hour time difference. Yeah,
but she's only 135 pounds. I think the jury may have bought into that, but as a matter of reality, given the condition she was in earlier in the evening, I'm just a little stunned that a jury would believe that there was this complete metamorphosis from intoxicated to, in control of her faculties. Of course, her good punctuation and coherent text messaging, I think, may have bought into or may have played into the defense narrative that she no longer was intoxicated, 3-4 hours later.
Exactly. Or that she never was. And I think that was more to my point, was that it just made sort of Rose's story more believable. I think, the defendants testified that they didn't see her drink very much, that there was only this one bottle of tequila that, that she may have taken 2 shots out of it. The amount is up in debate, but the bottom line was that she didn't really have evidence of that. And she didn't have evidence of any date rape drug either. And, she was able to testify, the judge let her testify that she felt that she was drugged, but there was never at any point any evidence, and her expert had to admit that as well.
Yeah, agreed. The lack of physical evidence really did doom her case because, you mentioned that it came down to a he said, she said. It was a great headline, and I don't know if it's a Deadspin article, but the headline was he said, they said. When you line up just the sheer numbers of witnesses who testified in favor of one side or the other, the Rose column, just by virtue of the fact that there were three defendants. So you have three, defendants, portraying, one version of events, backed up by former friends of the plaintiff. That was a killer. And these former friends came across as real. I don't know. I don't like to use the word sketchy. I don't know them. But it just seems somewhat questionable to me as to what their motivations might have been. It just seemed that there may have been some agenda there. But be that as it may, you had former friends of Ms. Doe testifying that she made the thing up and she was, looking for a lottery ticket. And when you just line up the sheer number of witnesses who testified in favor of the Rose narrative, which are, at least 5 people, if not more, and then on the Doe narrative or the Doe side, you have, Ms. Doe and then maybe her ex-boss, which could have been a critical development for the plaintiff side. You have the only person without any axe to grind, without anything to gain, supporting Ms. Doe's version of the events, but it just wasn't enough.
Right. And my initial impression of the two witnesses on Rose's side, the quote-unquote ex-friends who were testifying against her, was this is crazy. Like, why would a friend come out, not only testify that she's lying, but do it so vehemently? One of the ladies actually leaked text messages to balleralert.com earlier in the case, and the other one came out with this very strong declaration later on. But the bottom line was, we heard from the jurors after the trial, and one of them actually said that they found Chavez, which is the one with the declaration, that claimed that she bluntly asked Doe whether she was raped, and Doe said no. The jurors said we found her very believable. And so I think, you're dead on with your point that those other witnesses were key in this case.
Yeah, with friends like those, my God. And I reading her testimony from a distance, I thought she came across poorly. But when I spoke with Julia Marsh, who was in the courtroom, she's the, reporter from the New York Post. Julia actually thought her testimony may have come out, quite well and believable. So it's really the former friends that I think tipped the scales, towards the Rose side. And what really concerned me from an evidentiary perspective is that Kayana Laverne, one of the former friends who gave a video deposition, she left the jurisdiction right before, several weeks before the trial, and I found that very troublesome. When you add that to the fact that Rose's lawyers happened to be representing her, I just thought the circumstances surrounding her testimony raised more questions with me than her testimony ever answered.
Yeah, and so just to clarify that point, the reason why it's important that Rose's lawyers were representing her is because they claimed attorney-client privilege at the deposition and refused to answer a number of questions about what her motives were and things of that nature. And then they were anticipating, they being Doe's lawyers, of being able to cross-examine her at trial about these issues. And then she moves, a week or two before trial to Miami, and they, file an emergency motion to have her come or have another chance at a deposition. And the judge says, no, she's not that important of a witness, so I'm not going to allow it.
She turned out to be maybe a critical witness in absentia. Do you think this could be a valid basis for seeking a new trial?
I think it's an argument that they might make. I think the fact that there was another witness saying the same thing is really going to hurt Doe's argument on that point. It's just sort of putting the tallies in each column, but the standard is, would it completely have prejudiced Doe? And I think the answer to that is, probably not. It's probably closer to some, non-material error. What do you think?
I think standing alone, it's not enough. But when you add them, when you add each of the potential grounds for a new trial, and there are going to be a number of them, probably focused on the jury instructions, the denial of in limine motions, or the granting of in limine motions, that no one item standing alone is by itself the basis for a new trial. But when you tally them all up, and you consider the number of alleged mistakes in the aggregate, I think it could materially prejudice or have materially prejudiced, Doe's case. I'm not in a position to assess it now. I don't know what the arguments that are going to be raised, but I'm just anticipating that it's going to be a laundry list of different items. Some will have more weight than others, but I think when you're assessing the prospect of getting a new trial as opposed to a judgment notwithstanding the verdict, I just can't see how a JNOV motion would be granted here with all that evidence, particularly conflicting evidence. I think Doe's only hope here would be that there are enough errors of law and mistakes that the court made to kind of push it over the line for securing a new trial.
Right, and just to kind of clarify what you're talking about, the JNOV motion is basically asking the judge to overturn the verdict because, as he was observing the trial, there was so much evidence to the contrary of the verdict that they couldn't have possibly gotten it right, as opposed to, a motion for a new trial, which it instead highlights the errors, the procedural errors in the proceeding. So they're kind of two different categories of motions, for those out there that aren't trial lawyers. Before we get too far afield, I wanted to go back and talk about some of the evidence that you thought maybe was stronger in Doe's side of the column. I know you said you had a shorter list on that side, but was there anything that stuck out to you?
It's a shorter list, but not a short list. I have 3 pages of yellow legal pads worth of notes where I've numbered different factual items, and I'm in double digits. So she had plenty of good facts and evidence on our side. First and foremost, you have Derrick Rose admitting during a deposition that he didn't know what the meaning of consent was. I mean, my God. I don't care what your level of education is. Consent is not an intricate, complex legal concept. It's a word that just about every layperson should understand. We consent to things all the time. It is not while it is a term under the law and it has legal significance, it's also something that should be understandable by lay people. And he openly admitted that he didn't understand the meaning of consent. And he described the trip over to Ms. Doe's house in very crude, a very crude way that, we men, he came across as, I wouldn't say a sexual predator. I wouldn't go that far, but this was almost like a booty call.
Right. And I think that's how their relationship was ultimately defined. And, I think the jury had to make the determination whether in their minds, that was okay or that had anything to do with whether consent was given.
Yeah.
I had a couple things that stuck out to me throughout the proceedings that maybe didn't get as many headlines as, some of Rose's deposition testimony. But, her roommate came home that evening and was there, and there was this kind of odd situation where one of the defendants, they don't actually never came out who it was, like kind of tried to chase her into a room, but then it came out, he said he was looking for the bathroom. But in any event, she was around the next morning, and I think one of the things that struck me as strong in Doe's column was that she testified that Doe asked her the morning after if people were even over at the house, because she was, disheveled. She had woken up with her dress around her neck and lube all over the place, and I think that was a good fact for her version of what happened, which struck me. And then, I think another thing that led in her favor was that the defendant's stories didn't really match up completely. And both other co-defendants, Hampton and Allen, testified that Rose is very forgetful and he forgets all the time. And that was sort of one of their themes during testimony and trial. And I think the jury could have read into that a few different ways, but obviously they found the other defendants to be believable in that respect.
Yeah, I mean, you can only rehearse your clients so much, but the fact that it was a joint defense effort with some very able lawyers and probably incredible amounts of witness preparation, it was surprising to me that their stories didn't line up. Maybe they lined up on the ultimate, issues, but on the timeline and in the number of minutes between events, it just seemed to be all over the map. And considering how over-prepared they must have been, that was kind of shocking to me. And the jury obviously didn't find that to be a troublesome fact, but as somebody who's trying to listen to the testimony, it stuck out to me that their timelines deviated from one another so significantly.
Right, I agree, and I would point out that it seems like from what we've heard from people that were in the courtroom and what's been reported, that Rose was a much better witness at trial than he was in the deposition too, which is
can't get any worse.
Yeah, it's true. I mean, maybe the deposition made him take it a little bit more seriously. Who knows the answer? But
the deposition was preseason. The trial was the regular season and playoffs.
Right.
He's like the Allen Iverson of trial witnesses. Just practice.
Right. Practice? You want to talk a little bit about what we heard from the jurors after? I thought there were some interesting quotes that came out.
When they weren't busy taking photographs and posing for selfies, they were very generous with their time and spoke to some of the reporters afterwards. I mean, they just didn't find her believable. You had one juror who was ready to commit to Rose within 5 minutes based upon the absence of physical evidence. They just weren't buying what she was selling. And while the dynamic of an all-female jury may have played into Doe's preferences. I mean, you couldn't ask if you're a woman who's accusing a group of men of running a train of rape on you, you'd like to have a jury consisting mostly of women, okay? But that cuts both ways. Maybe the jury was turned off by some of the things that they heard during the trial about her, pre-existing, sexual incidents with Rose, with the lying. I think they may have been sympathetic towards her, but the jury just didn't believe her.
Right. That's the quotes. So there was 6 females and 2 males in the jury, and the females' quotes were basically that they really wanted to believe her, that just the evidence wasn't there. I think one of them said that, the night after she got off the stand, she went home and cried because it was very sad testimony. But at the end of the day, she determined that the evidence wasn't there to support that version of what happened, and it is what it was. And then you hear from the 2 males, one of the males says it felt like Doe was playing us, quote unquote, and that he also thought that her tears on the stand were fake. So, there's a variety of different views that came out of the jury. And I thought that the one juror, as you mentioned, Dan, who said that he could have delivered the verdict within 5 minutes because there was no rape kit, that was definitely the most troubling quote to me. Obviously has no concept of how this works, or the fact that not just because a rape kit isn't available doesn't mean a rape couldn't have occurred. Not to say that, who knows what happened here, but...
And didn't even have to be a rape.
Right.
Sexual battery.
Right, and there was...
Civil sexual battery, which is at a lower threshold than a criminal rape. I think had there never been any rape kits, and there weren't here, but no police report, this is not a criminal case. This is a civil case about an unconsented sexual touching which caused harm. And I think the jury may have conflated the civil and criminal aspects of it, as did much of the mainstream, or not just the media, but many of the people following the case. When you read about or hear about, the gang, allegations of gang rape, you're thinking along the lines that this is a quote unquote quasi criminal matter or a criminal matter, and it wasn't. It was a civil case for money. And I don't think the jury could distinguish or differentiate sufficiently between the criminal aspects of it and the elements of the civil tort. And I wouldn't say they were confused, but I believe that they treated this almost like a rape case.
Exactly. Yeah, that was my thought as well. And I think, obviously it was also an interesting look to see them, as you mentioned, take pictures with Rose afterwards with big smiles and Rose's attorney.
Well, all I have to say about that is Ninth Circuit judges read the newspaper. I thought it was a terrible move and terrible look to almost act in a celebratory fashion after the fact. You take your win, put it in your pocket, because it's not over until it's over, and it's not over until the Ninth Circuit U.S. Court of Appeals affirms the judgment, and we're a long way from outright victory. And the one thing, I know this is a very emotional trial, very highly charged. The defense attorneys were accusing, the plaintiffs and accusing the world at large of trying to portray them as sexual deviants and to play the race angle. But it's a little bit too early to do the final victory lap. And taking the photographs with Rose and the judge's comments at the end of the trial, wishing Mr. Rose luck, except when he plays the Los Angeles Lakers. I don't know. They just it came off so tone deaf, and I think it's just bad karma. It's not obviously going to impact how an appellate court rules, but that's not the way you comport yourself at the end of a trial.
Yeah, I agree. I think that the judge in this case had several instances of potentially acting a little bit unprofessional, especially with that last comment. This is still allegations that a group rape occurred. It's completely tone deaf. I think you nailed it. And then you mentioned another issue which we barely touched on, or excuse me, didn't mention. You tweeted last night about another issue. Obviously, Jane Doe was allowed to remain anonymous through the entire pre-trial development in this case. Rose filed several motions to try to eliminate that. And the judge ultimately said during the actual trial, they're going to use her real name because otherwise it would have hinted to the jury that somehow she was guilty. And the parties continued to use the term Jane Doe in court filings. And then as soon as the verdict comes in, the judge filed a couple orders and he actually used her full name, which, I mean, what do you think about that? Is that premature?
We could have a new trial. The prospect, this case in all likelihood is over, with the emphasis on the words in all likelihood, because we still have deadlines coming up for Doe's attorneys to file a motion for new trial, a motion for judgment notwithstanding the verdict. There may very well be an appeal. And as infinitesimal a likelihood as it might be, there is still a chance that this case can go to trial again. And if it goes to trial, Doe's anonymity has been blown forever. I mean, I think the judge's orders last night in which he listed her full name, I'd like to think that was inadvertent because it's not so much that the jury hears her real or knows her real name, but to the world at large, she was given the pseudonym of Jane Doe to protect her from reprisals as an alleged rape victim. And she's still an alleged rape victim, even though the verdict has been rendered. No judgment has been entered thereon. No rulings have been entered on post-trial motions, and no appeal has yet taken. And now, through the judge's, I would call it oversight at best, and complete recklessness at worst, her name is now known to the rest of the world if you have an account on Pacer and you pay a monthly fee to subscribe to Pacer. And of course, we know that only lawyers and some journalists subscribe to Pacer. But the point is, her name now appears in a public record as a result of the judge's 3 orders entered last night. And I think that's a bit premature, and you may not be able to unscramble the egg.
Yeah, I think that's a great point. And, there was a couple other things that various lawyers that I've talked to about the case were a little bit up in arms about the way that he conducted the whole proceeding. I think one of them was waiting too long for a gag order in this case. One of the really interesting things that I had never been a part of, and I don't think you had either, Dan, but
Nope.
we were both on the Jane Doe conference call with the media in her, hour and a half interview where we could just ask her questions. What was that, 10 days before trial started?
Yeah, it was a couple of weeks ago. And, listen, you and I are practicing lawyers. This whole journalism and social media thing is kind of new to both of us. And the notion of being part of a press conference is still kind of new to me as well. And that was exciting. We got to hear her, and hear her side of the story and be able to ask questions. And I thought she came across, very positively during that scripted phone call. But I did like her, and it was one of the fun parts of covering this case, to go from just talking about it on Twitter to now being one of 8 to 10 people on a telephone call in a press conference asking questions of the accuser. And I think I asked more questions than anybody else. I don't know if any of them got answered. She didn't answer any of them directly. I got cut off, but it was. I had very good. I was very quick on the draw. I think I got the first question asked, and that was something I'll always remember being part of. And hopefully, it whets the appetite, and I'll keep parachuting into all these future press conferences and sports law cases, because they're fun. It's exciting to be part of this and to be in the trial, to be in the mix of things. It's we're observing and commenting and providing legal insight from a safe distance, but it's also helpful to be in the courtroom, to listen to the witnesses, to engage the case a little bit more intimately than we had been able to do previously.
Exactly. I totally agree. And it was an eye-opening experience. I did also find her, she was quiet, which is something that was also reflected at trial. I believe on numerous occasions the judge had to ask her to speak up. She was obviously, she seemed to cry through her entire testimony at trial, and that wasn't the case in the call. But she seemed pretty well spoken on the phone call, and I thought that she would have made a pretty good witness. Obviously less believable than the other side in the case.
Well, those text messages, though, completely belied her demure demeanor on during the phone call. Over the phone call, she sounded like the girl next door. You didn't hear words like, I guess on a podcast we can say anything we want, but the tone of her text messages is completely at variance with the tone that we heard during the press conference, and how she likely portrayed herself at the trial. And the jury may have bought into the narrative that this whole thing was an act, because the truth may have very well been how she portrayed herself in dealings contemporaneously and in text messages, and how she dealt with her friends and with Derek, rather than how she may have portrayed herself 3 years later on the witness stand.
Yeah, I mean, like we talked about before, I think that was huge. And that was huge into buying into her credibility. Not only sort of the type of person that she was portraying to be, but then we also saw the text messages and the punctuation that went to the intoxication part of the case. So that was real. Basically, the main key piece of hard evidence was these text messages and call logs. And so that, I think the jury, probably rightfully so, put a lot of weight on those types of things.
Yeah, well, Dan, that begs the question: Does your punctuation suffer when you've consumed alcohol? And mine's pretty bad anyway when I text and when I email.
It's a good question. I don't know. You can ask my wife.
Okay. All right.
One other thing, we're running low on time here, but we were talking earlier today.
This goes fast.
I know, right? We were talking earlier today about things that kind of caught our eye, and one of them was the Mark Bout closing, Rose's lawyer, and a few of his comments. Do you want to delve into what he said?
Oh yeah, I found it went completely over the line. You know, the issue in this case is one of consent and one of, you know, I guess which of the witnesses are most credible, whether the crime occurred. The judge was always, kind of focusing or narrowing the parties, stick to the facts, stick to the night in question. But during the closing argument, I think his name is Mark Bowdy. I actually called his law firm a couple of minutes prior to us jumping on this podcast to get the correct pronunciation of his name. But during his closing argument, I think he was like preying on or playing to juror sympathy by asserting that Derrick Rose would lose his. If you find Derrick Rose liable of committing this harm, regardless of the amount of money that's awarded, he will lose his Knicks contract and he will lose his Adidas contract. And I call bullshit on one of those two. First of all, the Knicks gave up a bounty. At least, you know, from where I sit today, they gave up a lot in the way of assets to acquire Derrick Rose. He could have shot somebody, and the Knicks are not walking away from that contract. There's no way, no how. But it does crystallize the point that, Bowdy was discussing irrelevant and prejudicial, highly prejudicial things during his closing argument that had no relevance to the case and whether consent was given. He was trying to persuade the jury that, look what's going to happen to my client if you find that he did what he's accused of doing. He's going to lose his career. He's going to lose his endorsements. And I was shocked that Joaquin and the plaintiff's other attorneys did not lodge an immediate objection, because that kind of closing argument would be grounds for a new trial, in my opinion, had there been a contemporaneous objection. Now, without an objection, I think it would, I know I'm getting into the weeds of criminal procedure and trial practice, but it's a harder argument to make in asking for a new trial when you didn't object to the closing argument when it occurred. I think the plaintiff's attorneys will now have to show a fundamental error occurred, and I don't believe that Bowdy's argument focusing on Rose's career would rise to the level of a fundamental error requiring a new trial. It should have been objected to. The judge should have just put the hammer down on that immediately, and I think it crossed the line. It had nothing to do with the case. He shouldn't have done it, and it may have impacted the jury.
Right.
Besides which, it's not true.
Right. That's what I was going to say. It was basically a complete lie. There's no grounds.
Lawyers lying
for a guaranteed NBA. No grounds for an NBA guaranteed contract to be revoked and him to not get the money based on a civil lawsuit. There's really no precedent for him to even be suspended for a civil lawsuit. I think, under Adam Silver's power, he would be able to do so. He's just never done that in the past before. So, it would be hard to see how any of that would be true, even just a suspension aspect. With regards to the Adidas contract, in the morals clause, we don't know exactly what that said, but it's likely that.
How much is that contract worth?
He's got $100 million left on it. So I think over 5 or 6 more years, when he signed it, it was the biggest endorsement deal in all of sports. It's a huge deal. And with all these morals clauses, it really comes down to a business decision whether Adidas would want to get out of it from a business perspective, and then they look at whether they have the legal standing to do so. Public perception may have played a role in moving forward, but we saw Adidas come out yesterday, unsurprisingly, in full support of Rose and say that their contract situation remains unchanged or something to that nature. So,
what else could they say? I mean, if you gave those executives truth serum and wanted to know their innermost thoughts right before the verdict, I mean, let's face it, we know which way they must have been leaning. I mean, it's kind of a crass, craven, I wouldn't say crass, but it's a very cynical thing to say about human behavior. But believe me, if they had the chance to get out of that contract, they would be sprinting to that place. I mean, that is a horrible contract in retrospect because of Rose's injuries, and he's no longer the face of the Bulls. They're paying him $20 million a year, and I'm not sure that he's selling $20 million worth of sneakers.
Yeah, I agree and I disagree. He's certainly gone down in value since he signed the deal. I was a Chicago native. I used to have season tickets. He was an extremely popular athlete in the city of Chicago. But at the same time, if he was traded to any market, Adidas's ideal market would have been New York, the biggest market in the United States. And so that's going in their favor. They've already invested all this research and development, marketing money in his image. So who knows? I don't think it's quite of a clear-cut call as you're making it out to be, but
I like that we have disagreements. I want us to have disagreements. It's normal. We're opinionated,
right,
and
right.
the more the better. That will commemorate our first disagreement on
Right.
that was fun. I think you could be right. I mean, it's just it's a collateral issue whether or not Adidas would want to get out of the deal, but it certainly is interesting that they had a lot riding on the line. And the outcome of this civil trial could have saved the company potentially $20 million a year.
Yeah. And speaking of things that we do agree on, we talked, I think, earlier about the remaining criminal investigation. I believe the LAPD came out and said that it remains under investigation. But I don't want to speak for you, but I think we both agree that is very unlikely to go anywhere at this point.
I 100% agree that now, 3 years after the fact, following a civil jury verdict in favor of
evidence,
in favor of the defendant, in the absence of physical evidence, if you can't meet preponderance of the evidence, you certainly ain't going to meet beyond reasonable doubt. I think to the extent that there's any investigation going forward, it might be to maybe interview some of the individuals that Doe spoke with in the immediate aftermath of the of the alleged incident. But this is going nowhere. Even had it been a plaintiff's verdict, I think it would be a difficult case to prosecute without any physical evidence and conflicting witness testimony. You've got beyond reasonable doubt is a significantly higher threshold than preponderance of the evidence. I mean, it's like 51% versus almost 100%. It just wasn't going to happen. And I think the LAPD said the diplomatic thing, but with the lead homicide detective having committed suicide, I wouldn't characterize, or I'd be hesitant to characterize that investigation as an active one.
Yeah, I totally agree. And the point that you just brought up about the lead detective was one of the more bizarre aspects of this trial. Obviously, this was one of the. I think Shelley Smith of ESPN was. I heard her do an interview yesterday, and she said it was the craziest trial that she's ever covered. And it ranks up there for ones that I've seen as well. With that being,
we should have been there. You and I should have been there. I mean, the most exciting thing about sports law is to be in the courtroom. To watch this stuff unfold, it is riveting. It is absolutely riveting to, I was lucky enough to observe some of the Third Circuit oral arguments in the New Jersey sports betting case, Christie 1, Christie 2. I was at a TRO hearing in the DraftKings and FanDuel case last year, but a full-blown, real deal trial with this kind of testimony, it would have been a blast. To have observed it, and I think it might have, might have helped us understand how the jury reached the verdict that they did. But you and I think we need to attend some of these trials and have a chance to, at least be in the lion's den for a few of these going forward, because it's like night and day.
Right, and it's part of what we were describing here, and I've described in writing, is that the best thing to do is follow the testimony, but not only what they say, but how they say it. So it is difficult to really get a grip on what the courtroom dynamics were like if you weren't there. And to that point, we're going to try to get at least one of the reporters in the courtroom on a future episode of the podcast to talk about those sorts of things and sort of what her feelings and impressions were.
You just gave it away. Her?
Yeah. Well, there's a few hers.
We're down to three. Three possibilities.
Right.
Julia Marsh of the New York Post, Nancy Dillon of the New York Daily News, and Diana Moskowitz of Deadspin. So we'll leave it to the audience to speculate who our mystery future guest is going to be. But, to that point, Twitter... Now, forget Twitter. These four reporters, including Joel Rubin of the Los Angeles Times, did yeoman's work in the courtroom. I mean, considering that no major networks, television networks, except to some limited degree ESPN, covered the trial, the work of those 4 reporters, it felt like being there.
Yeah, and it was literally a workout for their thumbs because they were not allowed to tweet or write or bring any electronic devices into the courtroom. So they get these short breaks, and all of a sudden, your Twitter feed would just start popping off with various things that were said at trial. So it was a fun way to follow the trial, and I'm sure that they were ready to go, but probably have some good stories about what happened at trial that we haven't even heard about yet.
Yeah, if we're not following them on Twitter, if they're not tweeting during the courtroom breaks, we learn nothing. I mean, this case wasn't televised. News filtered out, only through these 4 individuals, and I just felt, like I was experiencing the trial day in and day out. I mean, I can't tell you how many times I refreshed Julia Marsh's Twitter feed to wait for the next, nugget or next tweet coming out about the testimony or the conduct of the trial. I mean, come on, right around the time of the verdict, I must have refreshed her Twitter feed 3 times per second. Okay, and they did wonderful job covering the trial, which leads me to the next point: is why did it take so long for the mainstream media to become fascinated by this case? I think you, Dan, were the first person in on this case. You were the date of the filing of the lawsuit. You were all over it, and were basically operating in a monopolistic situation for 8 months. Why did you become intrigued with this case?
Yeah, so I did. When it was first filed, there was some media fanfare, and I wrote an article for Bleacher Report at that time, kind of explaining just a very high-level background of the case and the proceedings and what I thought would happen. I actually predicted a settlement, which was wrong. Not the first or the last time that'll happen. But then everything went quiet, and,
Not you.
No, and I was... I wasn't writing as much, but I was definitely tweeting, keeping up with the docket, following it. And there was a handful of other people that were interested in it on Twitter. I mean, mostly it fell on deaf ears. But I would get every once in a while, people saying, "Why is this case still going on? Why are we talking about this, etc." And it kind of befuddled me. And then, I guess about a month out, I wrote my trial primer. There was Lindsay Gibbs for Think Progress wrote a really good piece right around that time as well.
She did great work too. I didn't mean to omit her name from the 4 horsemen of Joel, Julia, Nancy, and Diana. Lindsay was one of the most interesting reporters covering the story, and had some great insights in her Think Progress piece and just all along the way. So I've enjoyed reading her material, and she kind of created this next wave, but all of it seemed to take place within a couple of days. It just, like, one after another, these Rose articles started popping up at some point in August.
Right.
And, but you were, you can claim to be the Neil Armstrong of the Derrick Rose case.
Thanks. I will, I'll make myself a plaque, put it on my wall. But no, it was fun. I think what sparked it was during some of the motions in the court, some of the text messages were revealed, and we got a little bit deeper understanding of what the evidence was going to be at trial. And then, the general public found that interesting. My trial primer, I think, got as much traffic on one article as my website had up to that point combined. So there was obviously a huge demand, and not a lot of people are, working on it. And then I think it picked up, but it didn't quite get as feverish as I thought it would, considering what was really happening at trial and some of the wild twists and turns, especially in as you mentioned, sort of the TV coverage never really caught up. But, there's a lot of other stuff going on right now. And
this is an NBA, former NBA superstar who's still, a big name. And I'm surprised that the ESPNs, the Foxes, CNBC, MSNBC, they didn't have people at the courthouse, because I could tell you that there was a demand for information about the Derrick Rose trial. You're seeing it on Twitter. Someone like Julia Marsh, her Twitter following, quadrupled spiked up significantly. Twitter was the main source of all the news. And you mentioned that the hits to your website may have ebbed somewhat once the trial started. It's because that's Twitter became the broadcast channel. It became the Derrick Rose broadcast network for all things relating to the D. Rose trial. But certainly your work during the trial, but also the articles that you wrote in advance, the trial primer. I mean, how many hits did you get?
It was a lot. It was a lot. The trial primer
was this like proprietary information you won't tell me?
No, I just haven't looked recently. I think the trial primer hit about 50,000, which
whoa.
for a relatively smaller little spot like mine is a lot. So
hope you raised your advertising rates.
Yeah, I know, right? Hopefully we'll get a little bit more out of that. So yeah, it was a blast covering. I mean, I think we're just about out of time, but do you have any concluding thoughts to leave us with, Mr. Wallach?
That's heaping a load of pressure on me. Let me see if I could deliver. One of the things that intrigued me, or one of the dimensions of this case that I found fascinating, were the themes that each side, it's not just simply throwing evidence out there, but you're trying to advance this narrative, your story. And I found the higher level theme that each side brought to the case of Rose trying to portray Doe as a sexually aggressive, orchestrated. Can you imagine one woman orchestrated everything and portraying her as a gold digger who was just out for Derrick Rose's money? That was their theme, and they stuck to that theme from the beginning of time all the way to the end, never yielded. And I think they threaded enough of those needles to make the jury believe that narrative. And on the other hand, you had the Doe story, which was, I mean, come on, you have a woman who's never consented to group sex with Derrick Rose in her entire life, all of a sudden acquiescing to activity like this several years after she started a relationship with Derrick Rose, separated by 5 months from the last time she saw him. I think the train of rape narrative was a very compelling one, and I was surprised that more jurors didn't give it, credence, because, after all, how many women are going to consent? I mean, it's kind of a loaded question, but it's hard for me to accept the premise that a woman in that condition, who's steadfastly refused to sleep with multiple partners involved, plus Derrick Rose, would all of a sudden, after not seeing him for 5 months and being allegedly severely intoxicated, agree to have sex with 4 men. And that was the theme that the Doe side tried to portray. So looking at the different narratives and storylines that each side tried to present, that's what fascinated me about the case.
Yeah, I think another sort of narrative was, what is the impact of a celebrity or an athlete have on a civil trial like this? And I think
in LA County, a lot.
Right. We saw that impact early and often. I mean, I think he had way more resources from a legal perspective. If you just looked at the rates that he was paying his experts compared to what she was paying their experts, they were exponentially higher. I think he had a larger team of attorneys.
He was paying for his friends' attorneys.
Yeah, he was also paying for his friends' attorneys. So there was obviously a lot more money to go around to cover these sort of quote-unquote better services. But then you also look at the impact that his celebrity had on and right after the trial. I mean, we talked about these jurors wanting to take a picture with him right after. We talked about the judge making this comment saying best wishes except when you play the Lakers. And you just remember that these, there's still an athlete in these people's eyes, and is he treated differently because of that? Maybe not. I don't know. But it's always sort of looming over what's going on.
I mean, some of the jurors were starstruck. The judge even treated him almost like a celebrity rather than a citizen. I mean, the star fuckery of our legal system continues.
Right.
And those who can afford the best lawyers in town get the kind of justice they pay for. And I'm not commenting on the merits of this case. This may very well have been the correct verdict. But when you have two sets of lawyers being paid by the hour, and they're some of the best lawyers around, and you spend several $1,000,000, I think conservatively, this had to have cost Derrick Rose in the low to mid seven figures to defend his reputation and defend his friends. And on the other side of the coin, you had Joaquin. I'm not good with his last name, but the two lawyers who are probably working on a pure contingent fee basis. No money is coming in, and they collect only if Doe collects. So while one side was earning millions and probably worked incessantly to keep earning, the other side was getting nothing. And that may have reflected in the type of justice that was meted out here. Yeah,
I totally agree. And I think on that note, it's probably a good time to wrap up our first episode. Thanks, Dan.
No, Dan, it's been a pleasure. I have to thank you for conceiving of this idea. I wish I was smart enough to know how podcasts work, and I'm not. I wish I was prescient enough to have thought of the idea first. I was not. My being on this podcast is largely attributable to your vision. I'd always wanted to do something like this, and I hope that this is the beginning of a beautiful friendship and a long partnership. And I know we're gonna get better at this. Hopefully, the first one wasn't too bad. I think we were above the Mendoza line today. And hopefully going forward, this is something people are going to enjoy. And most of all, even if nobody listens to it, I enjoyed it.
Right.
And this was just fun to talk to you. So looking forward to more episodes. And thankfully, the world of sports law will not let us down.
Yeah, and we've seen that in the last 2 days. We have this Josh Brown diary coming out, and University of Louisville, some serious allegations levied by the NCAA. So sports law never sleeps, and we'll be back with episode number 2 soon. Thanks, everybody.